All right, now calling the matter of State of Georgia versus Michael McGrder, charged in warrant numbers 2025 WA03649, that's aggravated assault, and 2025 WA03650, possession of prohibited items. Representing the state is ADA Pitts. Representing the defendant is Attorney Oden. Your witness, ADA Pitts.
Thank you, Your Honor. Deputy Johnson, if you would be so kind as to raise your right hand. Do you solemnly swear and affirm that the testimony that you give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. You can put your hand down, state your name and your agency. Deputy Johnson, do you have any light where you are?
Yes, I can cut on the light.
It'd be helpful, sir. Okay.
Deputy Johnson with the Clayton County Sheriff's Office.
Okay. How long have you been with the Clayton County Sheriff's Office?
2 years.
Are you post-certified?
Yes.
And bringing your attention to June 12th of 2025, were you working in your official capacity with the Clayton County Sheriff's Office?
Yes.
And what are your duties with them?
I'm assigned to the Cobra unit.
You said Cobra unit?
Yes, ma'am.
And what is the Cobra unit?
We're a crime suppression unit that we patrol high crime areas and also do other things for the sheriff's office that are needed at the time.
Okay. So on June 12th of 2025, were you working in your official capacity with the Cobra with the sheriff's office?
Yes, ma'am.
Okay. And did it entail you being called in on a case involving Mr. McGrder?
Yes, ma'am.
Okay. Can you please tell the court you were called into the sheriff's office, to the jail, is that correct?
That is correct.
And the address to the jail, is that at 9157 Taylor Boulevard in Jonesboro?
Yes.
And is that located within Clayton County?
Yes, ma'am.
Can you please tell the court why you were called in on June 12th of 2024 and with the incident involving Mr. McGrder and Mr. Moy?
I was called in due to Mr. McGrder and Mr. Moy being in an altercation in Housing Unit 3. By the time I got there, they had already been separated. So I went into central control where I spoke to jail supervision, and they stated that Mr. McGrder and Mr. Moy was involved in an altercation that resulted in Mr. McGruder stabbing Mr. Moy. I believe it was in the arm or shoulder or something. And I watched the video footage of the incident, and it showed that
Objection, Your Honor, regarding the officer testified about what he saw watching the video. I called to the court's attention the best evidence rule, OCGA 24-10-1002.
All right, so those rules of evidence are relaxed in a preliminary hearing setting, so I'm going to overrule. Go ahead.
I watched the video of the housing unit, and I saw that Mr. McGrder stabbed Mr. Moy with a silver fixed object, and McGrder stabbed Mr. Moy due to Mr. Moy prior to being stabbed punching Mr. McGrder in the face.
And so this all occurred within the jail?
Yes, ma'am.
Okay. And the object that you saw Mr. McGrder have possession of, what is that, an object that is commonly referred to as a shank?
Yes.
Is a shank an allowed item for an inmate to possess?
No, ma'am.
Okay. And let's look at the aggravated assault. Based on your investigation, did Mr. Moy sustain stab wounds?
Yes.
Okay. And based on your review of the video surveillance, the CCTV, who inflicted those wounds on Mr. Moy with this shank? Mr.
McGrder.
Okay. And did you take out charges on Mr. McGrder?
Yes.
And what were the charges that you took out?
Aggravated assault and items prohibited by inmate.
Okay, and did you also take out a warrant against Mr. Moy?
Yes.
And what was the warrant that you took out against Mr. Moy?
Simple battery.
Okay, at any point during your investigation, did you observe Mr. Moy with any object that was prohibited for an inmate to have?
No, I did not.
I have nothing further, Your Honor.
All right, Cross.
Yes, please. Deputy Johnson, where was Mr. McGrder when this incident occurred?
He was in the Clayton County Jail.
But where was he? Was he in the day room? Was he in
Yes,
the cell?
they were in the day room.
Okay, and was he seated?
No, they were both standing.
Okay, and were they in a conversation prior to the person, the other person hitting him in the face?
Yes.
Okay, were you able to determine what the altercation was about?
No, I was not.
Did you speak to them at all as a part of this investigation?
No, I did not.
Did, as far as you could tell, did Mr. McGrder do anything of aggressive nature toward the other person that caused him to be struck in the face?
No, I did not. I seen that they were talking or arguing. I don't know because it doesn't have any audio. And then I just saw Moy punch Mr. McGrder in the face.
And as a result of being punched, you saw Mr. McGrder strike Mr. Moy?
Not initially right after. They continued to talk. Then I saw Mr. Moy grab what appeared to be Mr. McGruder's mat and throw it from the bottom floor on the day room to the top floor. And as he was doing that, after he threw the mat, he was turned away from Mr. McGrder, and that's when Mr. McGrder started to stab Mr. Moy.
I have no further questions.
And any redirect?
No, Your Honor, not from the state, just argument.
All right, closing argument.
State or reserve?
Go ahead, Attorney Odom.
None on behalf of Mr. McGruder, Your Honor.
Say that again.
None on behalf of Mr. McGruder.
Okay, all righty. Attorney Pitts.
Your Honor, I believe that the evidence before the court that's uncontradicted is that the incident that involved Mr. Moy and Mr. McGrder, or Mr. Moy punching Mr. McGrder had ceased, and he had moved on, and his back was turned to Mr. McGrder when Mr. McGrder attacked Mr. Moy with an that has the potential or did cause serious bodily injury. Therefore, Your Honor, the state would ask that the court would find probable cause on the aggravated assault. And the testimony before the court is that the shank that was used to stab Mr. Moy is a prohibited item for an inmate to have. And so therefore, the state would ask that this case be bound over in its entirety.
All right, so based upon the evidence presented, I do find that there is sufficient probable cause to bind both charges over to the Superior Court of Clayton County. That's the order of the court.
Your Honor, that concludes my business. May I be excused?
Yes, have a great one.
Thank you, Your Honor. Same to you.
All right, and then who are we doing next?
Your Honor, the state is ready on Mr. Porter. That would be, Officer Johnson, Deputy Johnson, you are free. Judge, is Deputy Johnson free to leave?
Yes, ma'am. Thank you.
Thank
Deputy
you.
Johnson, you free to leave?
Thank you.
That would be Detective Rosario.
Present.
And that would be for Defendant Porter.
Who wants a wet test?
How was your church?
All righty. So, Attorney Rogers, you're handling Mr. Porter?
Yes, ma'am.
Hold on, my light has gone out for some reason where I am. One moment. All right, let's make sure we're still on YouTube. We're still live. No, yes, we are. All right. So now calling a matter of State of Georgia versus Terry Porter, charged in warrant number 2025 CW 50843. That's armed robbery. And that's the only charge, correct?
Yes, Your Honor, it's the only warrant in this case.
Okay. All righty. Representing the state is 88 Pitts. Representing the defendant is Attorney Rogers. Your witness, 88 Pitts.
Thank you. Detective Rosario, am I saying that right?
Yes, I,
Okay. Please raise your right hand. Do you solemnly swear and affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
State your name and your agency.
My name is Detective Rosario with the City of Forest Park.
And Detective Rosario, how long have you been with Forest Park Police?
Going on 4 years.
Okay, and were you policing prior to those 4 years?
Yes.
And if you would briefly give an account of your law enforcement background for the court.
Prior to getting to Forest Park, I was policing for 4 years at Jonesboro, and previously before that at East Point.
Okay, and for Forest Park, what are your duties?
Forest Park, I'm a detective. I handle general cases that patrol can't handle and we get called out for.
And that you all get called out for?
Yes.
Okay. Bring your attention specifically to January 20th of 2025. Were you working in your official capacity as a detective with the Forest Park Police?
Yes, I was.
Okay. And did you have the occasion to respond to 4663 Waldrop Drive in Forest?
Yes, I did.
That located with me?
I'm sorry, you cutting up. You cutting.
Okay. Is that location within Clayton County?
Yes.
Okay. And can you please tell the court what the purpose of you responding to that incident location?
So I responded to Waldrop Drive in reference to an armed robbery. The victim had pulled into his house, and as he was walking up his stairs, he says males came from behind him and put the gun towards him. And then when he turned around, one of them hit him with the butt of the gun and took his wallet from him before getting back in the car and taking off.
Okay. And so, based on your investigation, did you have an opportunity to speak with the victim in this case as to essentially his movement that day?
Yes, I did.
Okay. And what did you learn about the victim's movement that day that pertained to this armed robbery?
So towards this moment before he got home, he was at the mobile gas station on Main Street in Forest Park in Clayton County. And there he was there with another witness that lives in the same apartment complex. That's where the suspects um met their suspect, the victim, or
Okay,
the victim.
okay. So you learned that he had been at the mobile gas station, is that correct?
Yes.
As it pertains to the mobile gas station, what, if anything, did you do to assist your investigation?
I use a flock camera along with Fuchsia's cameras and the video camera from the store.
Okay. And was the victim able to give you a description of the vehicle that the assailants had come from?
Yes, the victim and the witness.
Okay. And so what, if anything, did you do with that information?
So we checked our flock camera in the area of Mobile and Main Street, and we was able to get a positive identification of the vehicle.
Okay. And based on that positive identification of the vehicle, what you do next?
Contacted the register owner, which was a female. I believe her name was Miss Allen. And at that time, she said that nobody should be driving her vehicle.
Okay. And based on further investigation, did she actually identify some individuals that would have had access to her vehicle during the period of time of the armed robbery?
Yes, her son.
Okay. And what, if anything, did you do with that information?
So with that, continue. We did a search warrant on the vehicle. We ended up finding out that there was a receipt for the Army Navy store in Forest Park, as well as the victim's blank check inside the vehicle.
Okay. And what did the information about the Army, how did that assist investigation?
So I went to the Army Navy store after conducting the search warrant, and there you see Mr. Porter along with three other males inside the location shopping before going to the mobile gas station.
Okay. So to be certain, at this point, you have identified the defendant, Mr. Porter?
Yes.
Okay. And that identification video, was that before the armed robbery occurred?
Yes. Well, the when we got the video, I was able to get RISnet to do facial recognition, and it came back with a positive hit on Mr. Porter.
Okay. And so that video that you obtained, was that prior to the armed robbery happening?
At Army Navy store?
Correct.
Yes.
Okay, so Mr. Porter was with the vehicle that was identified involved with the armed robbery prior to the armed robbery happening, is that correct?
Yes.
Okay, and the video from the gas station?
So they from tracking them, they went to the Army Navy store, then went to the mobile gas station. As you can see, two males come out the vehicle, but Mr. Porter never exited the vehicle at the mobile.
Okay, and then from the gas station, were you all able to view on flock as well as on video that same vehicle following the victim to his incident to the incident location?
Yes.
All right. And then at some point, did you have an opportunity to speak with Mr. Porter about this incident?
Yes, after several attempts, we was able to get a hold of his mother's phone number, as mom was able to get us in touch with Mr. Porter. We brought him in for an interview, at which time we spoke to Mr. Porter about the incident.
Okay, and what, if anything, did Mr. Porter tell you?
Mr. Porter confirmed that he was with them that day, and that they were going to the gun store to buy a magazine for a firearm. He also, during the interview, confirmed that two of the males in the store at the mobile gas station confirmed that they wanted to do what is called a lick, that somebody looked like they had money on them.
And what did Mr. Porter relay to you what he understood a lick to be?
Basically, they was going to rob somebody.
Okay, and so that was the purpose of going to the Army Navy store?
From his understanding, they was only going to go to the Army Navy store to get a magazine.
Okay, and that was for the purpose of getting a magazine. We're talking about a gun magazine, correct?
Yes, gun magazine.
And that was for the purpose to hit a lick?
For my,
I'm gonna object. That's a leading question. She can ask him, if he stated what, but she's just asking him to confirm her theory right now.
So just restate your question.
Absolutely.
Area code 8563.
I apologize.
8563.
Detective Rosario, what did Mr. Porter relay to you what he understood the errands that they were running to be for?
They were just to get a magazine for a firearm, and that's it.
Okay. And so after they left the Army Navy store and they went to the mobile gas station, what, if anything, did your investigation reveal from there?
Mr. Porter confirmed that two other males in the car said they found somebody inside the gas station that seemed to have money and wanted to do a lick.
Okay. And what
Yeah.
happened after that?
That's it.
Excuse me. I couldn't hear the first part. The reception was a little shaky. I just wanted to make sure I heard it clearly of your last answer, Detective.
You were saying that Mr. Porter.
Mr. Porter basically confirmed that when they got to the mobile gas station, that two of the males got out the car and came back and said they wanted to do a lick on somebody that appeared to have money.
Okay. And based on your review of the video at the gas station, what happened after what Mr. Porter relayed to you as the setup for the lick?
So basically, they were gonna follow the victim to the house and go from there and rob him there. Mr. Porter did advise that there was guns in the vehicle, and they was in the back seat.
Okay. And based on what Mr. Porter told you and your review of the video, did they in fact follow the victim to a different location?
They did.
Okay. And based on the victim's statement, was he in fact robbed?
Yes, he was.
At gunpoint?
Yes.
Okay. And what happened thereafter?
So after he robbed, Mr. Porter then confirms that they took the wallet and they split the money amongst themselves, but he had no dealings in taking any of the money.
Okay. So to be certain, your investigation shows that the errand to the Army Navy store was for the purpose of buying a gun for a magazine, buying a magazine for a gun.
Mm-hmm.
Your investigation shows that they discussed hitting a lick.
Mm-hmm.
Your investigation shows that they identified the victim of the armed robbery.
Judge, I'm going to object again. It's leading, and some of it's asked and answered, and it's leading.
Your Honor, this is evidence that's already been ascertained.
Right, that's what I'm saying. It's been asked and answered. And
well, it can't be leading. It can't be leading. And
all right, and so I'm gonna overrule the ask and answered, and gonna sustain the lead. So if you could, I'm gonna allow you to lead because again, most of this stuff I've already heard testimony about.
Thank you, Your Honor.
So I think you're kind of reiterating what the officer has alleged. Okay, proceed.
Well, then I guess I just want to make sure I'm clear, because then the objection, if it's not leading, then it is asked and answered. I'm not sure how it could not be either one of them.
Okay, well, I'm going to overrule both objections. Proceed, ADA Pitts.
Thank you. Detective Rosario, so Mr. Porter confirmed, based on his interview, that a victim had been identified, correct?
Yes.
Okay. And then at any point during your review of the video, did Mr. Porter ever leave the presence of the group that committed the robbery?
No, they were all together. And from Mr. Porter's confirmation, they dropped them off right after committing the robbery.
Okay. And the information that Mr. Porter gave was that everybody in the car split the money that was taken from the victim except himself.
Yes.
So he was, just to be certain, he was present before, during, and after.
Yes.
Do you see Mr. Porter on this video?
I do.
And if you could point him out and, well, not point him out, but if you could describe something he's wearing.
Wearing the orange jumpsuit.
Your Honor, the record reflect that Detective Rosario has identified the defendant, Mr. Porter.
So reflected.
Thank you. I have nothing further, Judge.
All right, cross.
Thank you. Detective, I'm gonna assume you're the lead on the case, is that correct?
I am.
And I know you've discussed the alleged victim and the witness. Did you personally spoken to both of them?
I did.
And the conversations you've had with them, are they recorded?
Yes.
And as far as I'll ask about a few things you said on direct. First, I guess there seem to be two relevant videos, if I'm understanding it. There's one from the Army Navy store and the other one from the mobile gas station, correct?
Yes, along with Fuchsia's camera as well.
Okay. And if I'm understanding, what's the difference between Fuchsia's and Flock?
So Flock is a tag reader for a vehicle. Fuchsia is what's in our city that is like video on light poles and stuff like that.
Okay. So it doesn't read the tags, but it may capture the tag, but it doesn't read the tag. It just
Yeah,
kind of
that's what Flock does.
And so once you get an ID on the vehicle, you said you speak to the owner of the vehicle, correct?
Yeah, I do.
And let's get a little more specific about the owner of the vehicle. Who, to your recollection, you remember who the owner is?
I believe it was Miss Allen.
You said Alan?
Allen, yes.
And you said that, correct me if I'm wrong, I think you said that when you asked her about it, she ultimately told you that her son would have access to the vehicle. Is that correct?
Initially, she said nobody should be driving it, but then she's saying the only people that would have access to her house is her son.
Okay. And to be clear, is Mr. Porter her son?
No.
And I guess the son, did she specify what son?
No, she said she had three sons, but one that is not around.
Okay. Have any of the sons that she mentioned to you, have they been charged related to this incident?
Yes, I was able to positively identify them and take charges as well on them.
Going back to the videos, I guess the Fuchsias and the Flock, are you able to see who is driving the vehicle at any point?
From the Army Navy store, we could see who gets out of the driver's side and who's the driver.
Who, from what you can see, who's driving?
It was Miss Allen's son.
And just to keep it clear, not Mr. Porter, right?
No.
And when we talk about, I guess we've mentioned the alleged victim and the witness to the as far as you know, does the alleged victim know any of the suspects in this incident?
You sounded distant. I'm sorry.
No problem. I'll try it again. I said the alleged victim in this incident. Do you know whether or not they already knew any of the suspects?
If he already knew the suspects?
Right, prior to the incident.
No.
And just kind of pin that down a little more, as far as you know, is there any way that the suspects or the alleged victim, either or, would have known that the other party was going to be at that gas station at that particular time, to your knowledge?
To my knowledge, no.
And if I understood correctly, and I took you to be saying at the mobile gas station, I think you said two people get out of the vehicle, correct?
Yes.
Okay. And is either one of those people Mr. Porter?
No.
And have you seen video from inside of the mobile gas station too?
Yes.
Let me ask, and I know you really may or may not know, but do you know like what led to the alleged victim being targeted? Like, does he show some large amount of money or something there? Or
Well, you see one of the suspect walk by him and look over his shoulder as he was paying, but that's as close as it gets.
is he paying with cash to your knowledge?
Your Honor, at this point, I'm gonna object. I don't know that this goes to the probable cause of the armed robbery. I don't know that we're gonna allow the victim's conduct to say that he should have been armed robbed.
That's not at all where I'm going with the judge. You're on mute, Judge. Judge, you're on mute. I don't know if you.
I was just talking. I said, I know I didn't know that's where you were going, overruled.
Thank you. So what I was asking is, did you see if he was paying with cash?
No, I couldn't tell.
Okay. And then, but after that, if I understood correctly, you're saying the two people who are not Mr. Porter, they come out of the store. Is that correct? Okay. And then from that point, I guess the vehicles leave headed to the incident location, correct?
So the vehicle that Mr. Porter was in leaves first and waits for the victim to leave, and then they get behind.
Okay. And as far as the actual robbery that is alleged to have occurred, if I'm not mistaken, I think I've seen, and I'm basing this on what I've seen in the warrant, I think that there were supposed to be 3 people that are alleged to have been involved in the robbery, based on what the alleged victim and the witness are saying.
Yes.
Okay. Do they give you descriptions of the individuals?
He gave me what one of the suspects had on as jacket wise and clothing wise, but nothing facial or anything like that.
Okay. And just so I'm clear, but there's 4 people in the vehicle, correct?
Correct.
When well, let me ask, at any point, has there ever been any kind of identification, like a photo lineup shown to either victim or witness?
Yes, we did a photo lineup with the witness.
Okay. Was anyone, I guess, well, let me ask, I guess, who all, well, I don't want to assume too much. Number one, I guess, who put together the lineup?
My sergeant.
And who presented the lineup?
Detective Simmons.
And were you observing it?
Excuse me?
Okay, were you observing the identification process at some point,
No,
or
I
have you
was
seen it?
not. I was not.
Do you know whether or not was it recorded, like was it done on video?
It should have been Detective Simmons.
Okay. Based on the way you answer that, I don't want to assume, I'm guessing you hadn't watched the actual video of it happening.
No, I haven't. I just got word of when she did it.
And do you know who all? Well, first, I guess, was anybody identified by the witness in that lineup?
That photo lineup was for the driver.
Okay.
Was for Miss Allen's son.
Okay. Was there any sort of confirmation one way or the other?
No.
And to your knowledge, and I'm assuming you would know, has Mr. Porter ever been presented in a lineup to either the victim or the witness?
No.
And I know you said only the witness had done a photo lineup. Is there a reason that the alleged victim hadn't been part of one?
Because we've been trying to get in contact with him, and I haven't been able to get in contact with him.
And let's see. If I'm not mistaken, I guess you had a conversation. I think you described it as with Mr. Porter at some point, correct?
The interview?
Yes, sir.
Yes.
And if I'm understanding, I guess that it occurred at a precinct.
Yes, it did.
Okay. Was it, to your knowledge, was it successfully audio and video recorded?
It was.
Now, was he Mirandized before the conversation started?
Yes, he was. And he also signed the Miranda waiver as well.
And if I'm, as it stands right now, Mr. Porter, well, I guess first thing, when he first comes out, Mr. Porter, he's not in custody in the sense of he's not under arrest at that point, at least, correct?
No, he came in on his own.
Okay. And he's coming in response to receiving a call about the case from law enforcement, is that correct?
From myself.
And so, well, let me ask, because I know you said you had to go through mom and then mom got you in touch with him. Specifically, like, do you mean like she puts him on the phone when you talk to her,
So
or
when I found the number, I called her and she said, "Hey, he's right here."
Okay. So he was with her when you called,
Yes.
and then she put him on the phone.
Yes.
And so he agrees to come and talk to you. Is it the same day?
Yes.
And then at that point, y'all don't know where he's at, right? He doesn't.
Well, at that point he gave us his address.
Yeah, but I mean before he gives you the address.
No.
Okay.
Right, got it. Oh, good.
And
Huh?
so when he comes in, I just want to kind of confirm a couple of things. And if you recall, you recall. If you don't, you don't. But do you recall him telling you that while they were planning, the other people were planning the robbery, that he spoke against it to them, as in, why y'all gonna do this old man like that, or something along those lines?
He initially said, "Nah, that's not cool." And I asked him to reiterate, and he was just like, "Nah, that's not cool."
And just because I want to make sure I'm understanding, are you saying he told them, no,
He
that's not?
told them, "Yeah, that's not cool."
And going back real quick to the Army Navy store questions briefly. At the Army Navy store, do you know what not? Well, I guess there's a receipt. So what's purchased is what? Just a magazine, correct?
But my understanding, I couldn't confirm that it was a magazine because for that price, they said at that price it could be a magazine or ammo. So they couldn't confirm what it was.
But well, at least, well, let's put it like this. Can we say at least that, as far as you know, there's no reason to think that anyone purchased a firearm, correct?
No.
The video from well, I guess actually about all of the videos, Army Navy video, sounds like external video at the mobile and the internal video at the mobile. Um, do any of those have audio?
No.
And I just want to confirm a few things, and I think we'll be done. So Mr. Porter, he did not own the car, correct?
No, he didn't.
Okay. No evidence that he ever drove the car.
No, not from the videos.
There's no evidence he ever went into the store, the mobile gas station, I mean, to be specific.
No, there's he went into the Army Navy, got into the car that went directly to the mobile.
But yeah, but at the mobile, that's
At
what
the
I'm saying.
mobile, he didn't get out.
And I think you said did not, but it kind of, the audio got a little shaky. I just want to make sure I heard that right.
Yeah,
Said
at the
did.
mobile, he did not.
Okay. There's no evidence that he was ever armed, to your knowledge.
From my knowledge, I know he did state there were guns in the car.
Okay.
Who guns they were?
All I heard was the last part. All I heard was who guns they were, but I don't know if you said
I
something before
said
that.
He stated that there was guns in the car, but who guns they were, he didn't say.
Okay. Um, let's see. But as it stands right now, though, we'll keep going. There's no evidence that he chose that particular gas station or anything, is it?
No,
No evidence that he identified the target of the alleged robbery.
no.
And if I'm understanding,
Excuse me.
I'll say, well, no, I just kind of paused. What I was saying is, if I'm understanding, at the robbery, 3 people are alleged to be involved by both the witness and the alleged victim, correct?
Yes,
Okay. So that would leave 1 person in the vehicle, correct?
yes.
And there's nobody saying that guy was involved in the robbery, correct? Mr. Porter, that is.
Well, they couldn't. All they gave was what they had on. They wasn't who got out the car or anything like that. All they could give was a description of a jacket.
Well, let me ask this then, on the jacket that was described, do you know who's wearing that jacket based on the videos you seen earlier?
It was one of the other males.
And as it stands, there's no evidence that he received any of the proceeds. Well, it was just money taken, just cash? Is that all that
It
was
was
taken?
his wallet, but there was a blank check in the wallet along with money, and his debit card was used on Prize Picks.
Okay. Prize Picks, like the gambling?
Yeah,
Okay. Do you have any idea who used that card?
no, not as of yet. Try to do subpoena for it.
Understood. So as it stands right now, you don't have any evidence that he received any of those items? He hasn't been found in possession of anything?
No.
And if I remember correctly, and I think you're the one who took out the warrants, right?
I did.
I think there's a line in there where essentially you say that he aided and abetted because essentially he did not do anything to stop it. Is that correct?
Yes.
Okay. So at the moment, the basis of the charges because he was present and didn't do anything.
Well, he knew of the crime from the beginning to when it was going to happen to at this point, everything that went down, even after he didn't call law enforcement or anything, even after the crime had committed.
Okay. All right. No further questions at this time. Judge, you're on mute.
Any redirect?
No, Your Honor.
All right, closing arguments.
State will reserve.
All right, Attorney Rogers.
Thank you, Judge. Judge, we're gonna spend a little time in law school this morning. Not that we, haven't been, but I want to say a couple of things. And I want to kind of talk about the law and how it relates to this case. So there's a few things I want to get into. As I understand it right now, based on the detective's last answers there, and what's been testified to, he's being charged as a party to the crime of some sort. Because at this point, nobody's putting a gun in his hand, money in his hand, anything like that. And I think there's a couple of cases that are relevant to consider in this case. I'll start with one that is actually a federal 11th Circuit appellate case. But the reason I'm starting with that one is because it talks about Georgia law, and it does a pretty good overview of Georgia law regarding party to a crime. The case specifically is United States v. Roosevelt Coates, and this is 8F 4th 1228. It's a 2021 case from the 11th Circuit. And what it talks about, number one, is that a defendant, let me kind of, I guess, set the format. Essentially, what's going on is that there's a defendant who is trying to, I guess, kind of either minimize or get out from under their liability by trying to say that someone else is an accomplice. The federal court says that the defendant argues that Georgia law does not require an affirmative act in order to convict an accomplice of aiding and abetting commission of the crime. Yet the plain language of Georgia's party to a crime statute clearly requires some affirmative action in furtherance of the underlying crime, as it lists the specific acts that will suffice. Those acts include causing another person to commit the crime, aiding and abetting in the commission of the crime, advising, encouraging, hiring, counseling, or procuring another person to commit the crime. Court, it's still from the same opinion I'm still reading from, says, in addition, Georgia pattern jury instructions make clear that mere presence at the scene of a crime will not suffice to convict a defendant. The mere presence charge provides jury is not authorized to find a person who's merely present at the scene of the commission of a crime at the time of its perpetration, guilty of consent in an occurrence. I will add in, just because I'm not here to hide the ball or anything, the courts always talk about that you can consider a person's conduct before, during, and after. But I'll come back to that. But like I said, the court says that the jury is not allowed to do that, to find you there just for being present. And part of the reason I'm mentioning this is because the way at least I understand probable cause is that it would have to be either a reason to think that this person committed the alleged crimes, and you have to offer some sort of evidence to say that this person was somehow involved or did something to facilitate that crime. And that's not the case here. I could go on though, but there's a straight Georgia Supreme Court case. It's actually in a few different ones. It says mere presence or approval of a criminal act is not sufficient to render one a party to the crime, although criminal intent may be inferred from conduct before, during, and after the commission. One of the things I want to stress right there is that it says mere presence or approval. As I pointed out before, you can't approve of something that you don't know about. So the fact of knowledge in and of itself is generally not going to be enough to render anybody liable for a crime. The fact that I know somebody is going to commit a crime, the fact that I know they did commit a crime, none of this is illegal. It's not illegal to know something. It's not illegal to know that somebody else plans to commit a crime. It doesn't matter if you were riding in the car with them that whole day or not. If they decide, if you've been with them since noon and at 4 o'clock that afternoon, because they see a guy in a gas station that they think is a good target, that they decide to rob him, it doesn't mean that you got in and were part of that crime. A lot of times that's called being a witness if you see something happen. And there's no duty, and I haven't heard the courts or the state or anybody, to my knowledge, impose any sort of duty to stop crimes. That's not the law. There's not a duty to stop a crime from happening. There's not a duty to try to distance yourself as far or anything like that. None of these are requirements under the law. Not doing those things does not violate the law. And so that's what we have here, because it's clear that the fact of the parties being unacquainted beforehand, it's not a setup, in the sense of nobody lured the alleged victim to a location to rob him. There's not, when Mr. Porter's at this Army Navy store, I haven't even seen this alleged victim, so there's no intent formulated at that point to say that this is a person that we're planning to rob or anything like that. There's nothing to say that prior to the arrival at that store and their chance to encounter that anybody had any intention to commit a robbery at all that day. But then once we get to that mobile gas station, you got two people who get out of the vehicle, and neither one of them is Mr. Porter. So he's not the person who in the store spots the person, identifies a person, anything like that. He's not the driver. He's not the one that brought them to it or agrees to follow or anything like that. There's no reason to think that he's played any part at this point. And so what we have here is his presence and arguably knowledge. But what I'll say about that is that based on the conversation that they had or the interrogation that was had, Mr. Porter told him he didn't think that was cool. Now, I understand that's not, jumping up and down and saying, hey, guys, don't do it. I'm going to call the police. But if I tell somebody something's not cool, that means I'm not party to it. I don't want to be involved in it. And so at this point, we don't have any basis to say that Mr. Porter supplied the vehicle, supplied a weapon, supplied the alleged victim, was out of the car when the robbery occurred, that he played any part in it. And they need to be able to identify an affirmative act. That's what the court, the 11th Circuit was talking about, that there needs to be an affirmative act, as in you take some action to promote that. But here, we could remove Mr. Porter from the equation and the robbery, nothing needed for the robbery goes away. Nothing prevents the robbery if we remove Mr. Porter from the occasion. He's the one that came and talked to the police, and that's another one of my issues with these charges is that, Mr. Porter could have taken off. He could have not come to see the police, not been helpful to them and trying to determine who was involved in the situation. And if anything, the lesson I would take from this is that, it's not necessarily wise to help the police, because even if you're a witness, if you're not positioned cleanly enough for them, you're going to end up with the charges. But he didn't run from the case or anything like that. Another thing I would say is that there's no evidence that he received any of the proceeds. But even if he had received proceeds after for something that he wasn't involved in, which I'm gonna come right back to that, but just the logic of it, if he's not involved in it, I don't know why they would give him any of the proceeds. Like it doesn't make sense that he would receive anything if he's not involved in it. But what I was gonna say is that according to the Georgia Supreme Court, this one is Higuera Gutierrez v. State, 298, Georgia 41. At common law and under modern practice, an accessory after the fact is not considered an accomplice to the underlying crime itself, but is guilty of a separate substantive offense in the nature of obstruction of justice. But that's not the same thing as being involved in the actual crime itself. So, and again, let me be very clear. Even if he did not call the police after, he's under no, if there's a duty to report, I would ask the state to show it to you. But he's not under a duty to report a crime. He's not a school teacher and this is a child, a mandatory reporter. This is not that kind of situation. So he's not under a duty. And I think the fact of there being such things known as mandatory reporters lets you know that for some people there is a duty to report. That's not the case here. So the fact that he didn't report anything is irrelevant. The fact that he didn't stop the crime, again, no duty. He didn't take an oath. He's not a law enforcement officer. Irrelevant. They need to tell you what he did. He didn't drive the car. He didn't provide the car. He didn't provide the gun. He didn't get out the car. They don't have any evidence to say he did any of these things. And so those are my issues with this case, is that there's no affirmative act even being alleged. There is a need for an affirmative act to say that one aided and abetted. The courts have already said that mere presence and even approval of a crime, which not what we have here. We have disapproval of a crime, the only evidence we have. But even presence and approval is not enough to make you a party to the crime. So unless they can say he put a gun in somebody's face, he drove the car, he did anything other than sit there in a vehicle that he had been in prior to the occasion for the robbery even arising, they need to have something else to tell you about Mr. Porter than what they have. And so for those reasons, Judge, I would urge the court to dismiss this charge at the moment. If they come back with something, you know, the witnesses or the victims are saying he's the guy involved or something. But at this point, all they have is this man being honest enough with them to admit he was there, that, you know, what he saw, what he heard, but there's nobody saying he did anything. So for those reasons, Judge, the fact of the law of Georgia, just the general fairness of if you didn't do anything, you're not supposed to be charged with a crime. And if they want to charge you with a crime, they're supposed to be able to tell you what you did besides nothing. Like that's what he's charged with, is for doing nothing. And if doing nothing is a basis for somebody to be charged, I don't know who can't be charged with a crime at that point. Like law enforcement didn't do anything to stop it. Like if that's all it takes is not doing something, then who can't be charged under that standard, Judge? So for these reasons, I would ask that you would dismiss this charge for lack of probable cause. Thank you.
All right, go ahead.
Thank you, Your Honor. At this juncture, the state would point out that we are at the probable cause juncture, which just merely states that a crime occurred and that Mr. Porter probably was involved. I would agree with counsel that there are indications of crime, but I would also assert that there is a conspiracy type claim as well. I believe that the uncontradicted evidence in this case is that Mr. Porter stated that he did in fact know that this crime was about to happen. The point of going to the Army Navy store was to buy a magazine for a gun in order to hit a lick. The evidence before the court is that Mr. Porter was at the Army Navy store. So he did.
I'm going to object.
Wow.
I'm objecting.
Okay.
That's a mischaracterization of the evidence. They did not go to buy a gun. That's not what was testified to, Judge.
Say that again.
They didn't go to buy a gun. They went allegedly to buy a magazine, but there was no testimony that they went to buy a gun or bought a gun at the Army Navy store.
ADA Pitts, I believe that's the communication or testimony that I understand too. It was not.
And Your Honor, what I said was that he admitted that they knew they were going to the Army Navy store for the purpose of buying a magazine for a gun to commit the crime of armed robbery.
Okay.
That was what I said.
Okay.
Again,
All right, you
Judge,
can proceed.
I would also object, Judge, just that was not testified to.
Okay.
They went to the Army Navy store for the purposes of buying a gun to commit an armed robbery. That was not testified to, Judge.
Right.
And Your Honor, I would only ask that the state be allowed to finish its argument.
Yes, go ahead.
Thank you. I believe that the testimony before the court is that Mr. Porter told the investigators in this case that the purpose of going to the Army Navy store was to purchase the ammo, the item necessary to make a gun work, for a gun to commit the crime of armed robbery. And so I think the evidence before the court is that Mr. Porter knew and participated. The evidence before the court is that he was in the Army Navy store. I would submit to the court that every party to a crime may be charged with and convicted. We are not at the level of conviction. We are not at proof beyond a reasonable doubt. We are merely at a crime was committed and that the defendant was a party to it. As well as the theory of conspiracy. After leaving the Army Navy store, I believe the testimony is that the individuals involved then went to a gas station. After leaving the gas station, they positively identified a victim. And Mr. Porter tells the officers that he was in that conversation, that he was in the vehicle, that they, in fact, the vehicle was stopped. Mr. Porter was in it. They came back. They identified somebody. They had a firearm, which he communicated to investigators. They now have a magazine, which they all jointly purchased or were participating in purchasing together. They have now identified a victim. They then follow that same victim to his home, and then the crime is committed. What we know is that Mr. Porter was involved before, during, and after this incident. I do not believe counsel wants the court to say that the defendant has no duty to do any of the things that were indicated. He didn't have a duty to stop. He didn't have a duty to tell. He didn't have a duty to do any of those things. I would agree with you. I don't then think that you can, in the same argument, turn around and give him credit for now he came and talked to the police. The police identified him through their investigation. So you don't get credit for not doing anything and then turn around and get credit for allegedly coming forward and being helpful. That's a mischaracterization of the testimony before this court. The defendant was identified with the individuals who committed this robbery. He was identified through facial recognition. He was then contacted and he came forward, and his testimony is that he was involved before. He knew what was going on. He was at the incident location during, and then after the event, he was still with these individuals. The only information is the defendant mitigating, saying that he did not receive proceeds from the actual robbery. I don't believe that probable cause juncture is where we make that determination. There is still further investigation that needs to be done in this case. But based on his own testimony, based on the evidence that the detective testified to, in terms of the flock, in terms of the video, in terms of the statements from the victim and the I believe that it is uncontradicted that he knew. He was with the individuals as a party, that there was, in fact, a conspiracy based on his own testimony that this was going to happen. He was with them during and he was with them after. Therefore, Your Honor, I would submit that there is sufficient probable cause that Mr. Porter is a party to a crime and involved in the conspiracy to commit an armed robbery against the victim in this case.
All right. So after hearing testimony in this case, I do find that there's sufficient probable cause to bind this armed robbery over to the Superior Court, Clayton County. That's the order of the court. And then who do we have next?
Believe we have two left at this point, Your Honor. It's Mr. Trommels is not going, so just one, Mr. Judge.
All righty, can we get Mr. Judge, please?
And Your Honor, was there an announcement on Richardson, Trayvon Richardson?
That's Attorney Rogers' case.
No, there's been no announcement yet. He wasn't available.
Say that again?
I said he was not available to me, so there has been no announcement yet.
Okay, all righty, thank you.
Judge, who you call?
He called Marvin Judge.
88 Pitts, Your Honor. Am I excused?
Yes, have a great day. Thank you.
All right, thank you.
And this is Mr. Judge. Right, so he has two charges. Is that correct?
Yes, Your Honor, that's what I show.
Hold on one second, this light keeps going out. One. All righty, now calling the matter of State of Georgia versus Marvin. Judge, are you Mr. Marvin Judge? Just nod. Okay, all righty. Charged in warrant number 2025 CW 53082, participation in criminal gang activity. 2025 CW 53083, felony murder. Representing the state is ADA Pitts. Representing the defendant is Attorney Boware. Your witness, ADA Pitts.
Thank you, Your Honor. Detective Simmons, if you would be kind enough to raise your right hand. Your Honor, I'm sorry, may I have just one moment? 1 second. I apologize.
No worries.
One second.
You said that too.
Ms. Bower, you might be off mute, just so you know.
Oh, okay. Um, Judge,
Yes.
I don't know if you saw the chat. I
Oh,
believe we need a breakout room.
all right. Who needs a breakout room?
Me, you, and 88 Pit.
Okay. All right.
And thank you, Attorney Rogers.
Right. 88 Pitts can join room 1. All right. Gotcha.
Can you please check the chat?
Your Honor, thank you. State's ready to proceed.
All right.
I apologize for the
No
delay.
worries. You can go ahead and proceed.
Okay. Detective Simmons, please raise your right hand. Do you solemnly swear and affirm that the testimony that you give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Okay. State your name and your agency. Can you hear me? Please.
Detective Simmons, I can. Detective Simmons with Forest Park Police Department.
Okay, and Detective Simmons, how long have you been with Forest Park Police Department?
5 years.
All right, and as a detective with Forest Park Police Department, what are your duties?
To respond to any call outs that patrol aren't able to handle in any large cases.
Okay. Did you become involved in a case involving the defendant, in this case, Mr. Judge, on April 27th of 2025?
I did.
Okay. And the incident location, was that at 305 First Street in Forest Park?
It was.
And is that located within Clayton County?
It is.
All right. Can you please tell the court what participation you had in this case that involved Mr. Judge?
I was the lead detective on the case.
Okay. And if you would tell the court what the facts and circumstances of this case are?
On the date in question, there was a caramel curves round robin at that location. Round robin is just where one motorcycle club hosts and other motorcycle clubs come to support. They were hosting a round robin at the location, and they uh, two members of Wheels of Soul, Isaiah Mack and Anthony Hearns, were at the location. They are a known gang one percenter, as documented by law enforcement. Um, the Outcast Motorcycle Club, also known as the one percenter gang, documented by law enforcement, um, were notified that a rival gang was there and came to the location. Um, while at the location, the two victims were surrounded and by outcast motorcycle members, and ultimately they were shot and killed.
Okay, and you mentioned two different gangs. Have you, during your investigation, have you identified Mr. Judge as being a member of either one of the gangs that you mentioned?
I have.
Okay,
Outcast
and
Motorcycle Club.
so who was hosting the round robin?
Caramel Curves, which is a support club of Outcasts.
So essentially, the club that Mr. Judge is involved in they were the host.
No, a support club was the host.
Okay, all right. And so Mr. Judge's club, the Outcast, they came to the round robin?
Correct.
Okay. And on April 27th of 2025, the rival gang, who did you identify them as again?
Wheels of Soul.
Wheels of
Soul.
Are you saying stone or soul?
Soul, like in your body, soul.
Soul. Okay.
Yes.
So Wheels of Soul came to the round robin.
Correct.
Okay. And tell me, based on your investigation, what information led you to believe that Mr. Judge was involved in the shooting and ultimate death of the victim in this case?
So prior to the incident, Wheels of Souls was there with a person that they were supporting, a vendor that was a long-term friend, or was a long-term friend. Outcast was hosting church at their location in Atlanta. Church is basically a club meeting. And they received a phone call that the males were at the support club's round robin. Miss Mr. Judge placed himself at church and riding with the pack to the incident location and inside of the incident location prior and during the incident.
Okay. And so, to be certain, Wheels of Soul are at the round robin.
Correct.
And then outcasts who are not at the round robin get information that
You broke up.
Okay. I said that outcast members get information. They're at another location. They get information that Wheels of Soul are there.
Correct.
And in response to that information that a rival gang is at the round robin, they proceed to go to that incident location.
Correct.
Okay. And what happens once Outcast gets there?
They walk in. It was a group about between 20 to 30 members. They all parked on the road, walk in as a pack, look around, and then walk out. Then they go back to the bikes. Then they go back inside again and surround the two victims.
Okay. So 20 or 30 members of Outcast surround two members of Wheels of Soul.
Correct.
Okay. And what happens at that point?
They strategically place themselves, preventing the victims from leaving the event. A verbal altercation ensued, which led to a physical altercation. And one of the Outcast members attempting to strike one of the victims with a wrench. After that, um, the victim that was struck with the wrench was shot in the face, and the other victim ultimately uh, died as well. He was shot and killed as well on scene. They were the only two members of that group that were at the location.
Okay, and so to be certain, based on your testimony, two members of Wheels of Soul were killed.
Correct.
Okay, and please tell the court, specifically as it pertains to Mr. Judge, his participation in this process.
So his participation was coming to the event from their clubhouse to the Round Robin's clubhouse, um, knowing that they were coming to intimidate and harass the other group members. Um, once inside, they were once inside the venue. They surrounded the two victims and
And when you say they, are you including Mr. Judge in this?
correct.
Okay, go
Correct.
ahead.
And they prevented the males from leaving. After the males were ultimately murdered, they all fled the location, violating traffic laws, running the stoplights to elude capture. So upon police arrival, everyone aside of the one outcast member uh, that was injured was gone from the scene.
Okay. And did you have an opportunity to speak with witnesses that were at this incident location?
I did.
And based on those interviews, was Mr. Marvin Judge identified as a participant with the outcast members that caused the death of the two Wheels of Soul members?
He was by numerous anonymous callers and sources of interest.
Okay. And did you take out warrants against Mr. Judge?
I did.
Okay, and were the warrants for murder and felony murder?
And the gang act.
Correct. Yeah, I was gonna ask that one next. It was for
Yes.
murder. Is that
Yes,
right?
ma'am.
Okay, you also took out warrants for his participation in the in criminal gang activity. Is that correct?
Yes,
Okay,
correct.
you see Mr. Judge on this video?
I did.
And can you identify something he's wearing?
She's wearing an orange jumpsuit and a white t-shirt.
Your Honor, at this time, if the record would reflect that the detective has identified Marvin Judge.
So noted.
Thank you. I have nothing further at this time, Judge.
All right, Cross.
Thank you, Judge. Detective Simmons, you testified on direct, a gang 1% documented by law enforcement. What does that mean in layman's terms?
That the club was identified as a gang.
Okay, so the 1% documented means, what does that
That
refer?
they're outlaw club, that they don't abide by the rules of the
Okay, so there's
laws.
some sort of database that identifies gangs, and this is some
Yes.
confirmation through other agencies. I'm just trying to understand.
Through law enforcement professionals that work with gangs, they were notified. They were identified.
Okay. Now, you said that there was a round robin at a business that was being held, correct?
A support club.
A support club held
Outcasts.
round robin at
Correct.
a business, at an establishment, correct?
Correct.
Okay. Did this establishment have any audio or video camera system?
Not that I can recall. there was videos that was taken.
Okay. What videos did you review with regards to this case?
There were cell phone videos, videos from establishments around the area, and social media posts with videos of the event as well.
Are there any cell phone videos or videos from establishments that show Mr. Judge?
Yes, arriving to the scene.
And how does he arrive to the scene?
On his motorcycle. There were also Flock and Fuchsia's videos and still photos.
So you have flock camera of him arriving?
Correct.
And do you have flock camera of him leaving?
They all dispersed in waves. So yes.
And you said social media photo. What did you observe? Did you observe anything on social media involving Mr. Judd?
You broke up. I couldn't hear your
Do you
full
observe
question.
anything on social media that pertains to my client, Mr. Judge?
Not on social media.
How many witnesses did you interview with regards to this case?
There were multiple witnesses interviewed on scene by the supervisors and other detectives on scene. I spoke to numerous anonymous callers and sources of interest, and we have at least 9.
The sources of interest provide you with information pertaining to Mr. Judge.
Yes.
What information did they provide?
They stated that when he arrived and came in and outside the gate, he was observed as being a lookout.
Did any of the anonymous witnesses, sources of interest, or anyone advise that Mr. Judge possessed a firearm?
No.
Okay. Do you have any video or photograph showing Mr. Judge in possession of a firearm?
No.
And Detective, did you or anyone in law enforcement subsequently conduct an interview with Mr. Judge?
Yes.
And was that you who conducted the interview?
I did, as well as ATF.
And when was this interview, when were the interviews conducted?
Sometime after the incident, within possibly a week. I don't know the exact date. Is inside of the case file.
Sometime in May?
Yes.
Okay. And were you present when the ATF interviewed Mr. Judge?
I was.
Okay. And what, if anything, did Mr. Judge say with regards to his involvement in these incidents?
He placed himself there. He stated that he witnessed the entire incident, and they went in and out the gate several times. First to see if they could find the males that they were looking for. And then the second time is during the incident where the altercation and the shooting transpired.
And did he tell you, was the interview conducted under Miranda?
It was.
Okay, and he waived his rights?
He did.
Okay. And was this memorialized in any way?
Yes, it's on video.
Is that yours and ATF or just yours?
On mine.
Did he make any statements about possessing a firearm?
No.
And is Mr. Judge the only individual that you've charged with crimes?
You cut out again. You said
Is
if he's the only individual.
Is Mr. Judge the only person that you've charged with these crimes
No.
out of the 25, 30 people?
No.
How many people have you charged with these crimes?
4.
Did any of the, and that's 4 including Mr. Judge, correct?
Correct.
Did any of the other 3 make statements that pertain to Mr. Judge?
Yes.
Okay, what was said by co-defendants regarding Mr. Judge?
They also confirmed that he was on scene as well.
And were there statements that was the sum total of his participation is that he was present?
He was present, and they all went into, they all came into a pack. A phone call was received, and they all came in the pack with the sole purpose of harassing and intimidated the 2 deceased.
Mr. Judge did not possess a weapon, correct?
Not to my knowledge.
And he did not have physical contact of any kind with either of the 2 victims in this case, correct?
I'm unsure. It's still an active investigation.
One second. I think that's all I have, Judge.
Right, any redirect?
Yes, briefly, Your Honor. Detective Simmons, based on your warrant, did Mr. Judge have a specific duty during the murder of the 2 members of Wheels of Soul?
One of the sources of interest stated that he was the lookout.
Okay, and as the lookout, did he prevent people from entering or exiting the event, or exiting the scene or incident, or
Yes, he did.
at the time of this murder?
Yes.
Okay. And after the murder, did the defendant then flee the scene with the remainder of the members of Outcast?
He did.
That's all I have, Judge.
All right, closing arguments?
State reserves.
All right.
Your Honor, I will submit only testimony presented by Detective Simmons.
All right, based upon the evidence presented, I do find that there is sufficient probable cause to bind these charges over to the Superior Court of Clayton County. That's the order of the court.
Thank you, Your Honor.
Thank you. And you said we have one more remaining.
I didn't. Mr. Trommels is getting a new attorney. I think that was the only other person that I had identified at the onset. I believe that there was one individual that Mr. Rogers had indicated was unavailable that we didn't have an announcement on.
Richardson?
Yes.
It was just confirmed from the jail that he is still in the courtroom with Judge Scott.
Okay.
Oh, okay. All righty. And so we will go ahead and continue this one. This is Mr. Taylor.
Is that going to be the 7/23 date?
7/10/23, yes.
Okay. Thank you, Judge.
All righty, so let me go down and make sure we have everything.
Your Honor, we're still live.
Oh, okay, thank you.